and Student. Iron and Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Aradhya Dixit. She is going to deliver a lecture on essentials of contracts and its types. She is from KES Shri Jayantilal Patel College of Law. So without wasting further time, I would request Aradhya to commence with her lecture. Thank you.
Good afternoon everyone. Greetings of the day. My topic for today is what is contract? Its essential and types of contract. In simpler terms, a contract means when two parties enter into an agreement to fulfill some promises or obligations, and that promises or obligations will be completed by those parties only. And when such agreement becomes enforceable by law, it becomes a contract. It should be kept in mind that all the contracts are agreements only, but all the agreements are not contract. Now I would be dealing with the essentials of valid contract. So the first essential of valid contract is offer. Under section 2, subsection A of Indian Contract Act 1872, the offer is defined. It basically means to an agreement to do something or not to do something. It should be kept in mind that while giving an offer, the offerer, that is the person who is giving an offer, should be willingly to enter into a legally binding contract, and the person to whom the contract is given, or the person to whom the offer is given, is said to be an offeree. So when an offer is given to the offeree by the offerer with the intention to enter into a legally binding contract, and then the offeree accepts the contract, then in that condition a contract is completed. So there are some essentials of offer. The first essential of offer is that the offer should be communicated, and the communication should be with the help of reasonable mode of communication. Now what do you understand by reasonable? So here reasonable means through WhatsApp text, mails, message, fax, letter, or by a call. These all can be termed as the reasonable mode of communication. The offer should be accepted also in a reasonable time. And the offer must be clear, specific, and capable of being understood. It should not be vague or ambiguous. An offer should be lawful. It should not be to do an unlawful act. For example, if A gives an offer to B that if B will commit a robbery in the bank, then A will give him 1 lakh rupees. The offer is void at the first instance only, because the offer is not to do a lawful act, but it is to do an illegal act. Offer can be of two types, express or implied. Now the express offer means that the offer is expressed through words or it's written, and the implied offer is inferred through the acts of the offerer. An offer can be revoked at any time before its acceptance. Now I would be telling you regarding the promise. So promise is a combination of an offer and acceptance. As soon as the offer is accepted, it takes the mold of a promise. And once that all the conditions of a valid promise are fulfilled and it is enforceable by law, it takes the mold of contract. Contract Act defined an offerer as the promiser and the offeree as the promisee. The next valid essential of the contract is acceptance, which is defined in the section 2, section 2, clause B of the Indian Contract Act 1872. Acceptance means when the person to whom the offer is made has given his assent to such an offer. Now, though the acceptance is important, but in this situation, the acceptance should also be consensus ad idem, means the acceptance in both the minds of the offerer and the offeree should be same. For example, A says that he wants to buy rice from the B. Now, in the mind of A, it is there that A wants to buy some special kind of rice, but B understands it as a normal rice only. So here, though there is a offer, though there is a acceptance, but it will not be result into a valid contract because the meeting of minds is not there. Both the parties have taken the contract into some other sense, and it is a contract of different things for both the parties. So it will not be a valid contract. Now there are some essential pointers for acceptance as well. The acceptance should be absolute and unqualified. For example, if A is giving an offer to B that he is willing to sell his car for 1 lakh rupees. Now if B says that no, I want to buy the car at 90,000, then at the very instance this will not be a valid contract because the acceptance is not fully qualified. This will result into a different type of contract. But at the first instance, it will not be a valid contract because the acceptance is not absolute in the present case. Then the other essential of acceptance is that the acceptance must be communicated in a reasonable manner. Then the next valid essential of contract is consideration, which is defined under section 2 clause C of the Indian Contract Act 1872. A contract is formed when a person A makes an offer to another person B, and when such an offer is accepted by the other person, it becomes an agreement, as I have already told. But here the consideration plays a very important role. Consideration basically means value given to the performance of a promise. It need not necessarily be money. It can be anything which have a value in the eyes of law. Usually a contract without consideration is void, and a consideration need not to be adequate in all the cases, but it should have some value. It must be illegal or void or impossible to perform if the consideration is not adequate. For example, if A enters into a contract with B that if A will burn his house, then he will give him some amount. Then in this case, though there is a consideration, but the contract is to do an unlawful act. So it will be an illegal act because the object of the contract is not appropriate according to the eyes of law. The next valid essential of the contract is free consent. Section 10 of the Indian Contract Act 1872 mentions that to enter into a contract there should be a free consent. And according to section 10, it is specifically mentioned that if contract is valid only then when it is entered into by free consent of the parties. Section 14 of the Contract Act specifically defines free consent as consent given under coercion, undue influence, fraud, mistake or misrepresentation will not be termed as a valid consent. Section 14 speaks about the free consent, and section 15 of the Indian Contract Act specifically mentions regarding coercion. Coercion is basically anything which is unlawful as per the Indian Penal Code 1860. Coercion means an act when a person is threatening any other person to commit an act which is forbidden by law and which is forbidden by Indian Penal Code, then in that condition it will be termed as coercion. Mere threatening the person to file a criminal case against him will not be termed as a coercion. For example, I will explain this concept with the help of two examples. The first example is A threatens his wife to sign a contract, and if she will not do the same, A will commit suicide. Now this is a contract without the presence of free consent, as the person A is threatening his wife to enter into a contract, and if she will not, A will commit the suicide, and suicide is forbidden by law. It's not accurate, so it will be a contract without the presence of free consent. And the illustration B. So if A says that you are cheating, and if you will not take the certain actions, not make changes in the contract, then I will file a criminal complaint against you. Now this will not be a contract without the free consent. This will not be a case of coercion, because the person is just threatening him to file a criminal case, and to file a criminal case against any person is not forbidden by law. The next essential of free consent is undue influence, which is defined under section 16 of the Indian Contract Act. So, if the consent has been obtained by a person who is at a dominant position. Now here the dominant position can be a doctor-patient relationship, relationship of advocate and a client, principal-agent relationship also, basically the employer and employee relationship. So if the person who is in a dominant position compared to the other person influences the person to enter into a contract, it will be a case of undue influence, and such type of contract will not be termed as a valid contract in the eyes of law. The next essential of free consent is fraud, that is section 17 of the Indian Contract Act. So if the person genuinely and intentionally makes a false statement to compel the person to enter into the contract, then in that condition it will be a case of fraud. So if A fakes the document and presents to B that the house situated at some lavish area is of A, and B genuinely thinks that A is correct and enters into a contract. So it is a clear case of fraud, because A genuinely, intentionally and very well in all his senses committed this to compel B to enter into a contract. So it is a case of fraud, and in this situation B has an option to repudiate this contract, and this will be a case of fraud. The next valid essential of contract as per the free consent is misrepresentation. So if A misrepresent any fact to B without any intention of cheating B, then in that case it will be a case of misrepresentation. And the last aspect of free consent is mistake. If one or both of the parties enter into a contract having a genuine mistake in their minds, they are not clear with the terms or conditions of the contract, and they have committed a genuine mistake with not an intention to commit a fraud or a cheating against the other party, then in that condition the contract is voidable at the option of one party or both the parties if the mistake is of both the parties. So in that condition the contract will not be valid if the mistake has been committed, but it can be valid if the person against whom the mistake is committed is willingly trying to continue the contract. The next essential of valid contract is the capacity to enter into contract. So there are two essential conditions to enter into a contract. Firstly, the person should not be a minor. It should be of 18 years, minimum 18 years of age. Then the next essential is that the person should be of sound mind. If the person is of unsound mind and is not in situation to understand the terms and condition of the contract, then in that condition, if he or she enters into a contract, it will not be termed as a valid contract. For example, A is a lunatic person and enters into a contract with B to sell his property at just 1000 rupees, then in that condition it will not be termed as a valid contract, because the A was not in the senses. He is a person of unsound mind. He is not capable of make rational decisions. Then in that condition, this will not be a valid contract. The last essential of valid contract is lawful object. So, section 23 defines unlawful consideration. If the contract is to do something unlawful or illegal, then in that condition, this contract will not be a valid contract. So there are specific conditions when the contract will be forbidden by law. The first is that if the contract is forbidden by law, then it will not be a valid contract. If the contract is of such a nature that if permitted, it would defeat the provisions of law. For example, A enters into a contract with B to supply marijuana at a cost of 1 lakh rupees. So this will not be a valid contract because the marijuana is banned in India. So if this contract is permitted, it will beat the provisions of law. The next essential is that the purpose of contract is fraudulent. The next is if the contract involves or implies giving injury or damage to someone or someone's property. For example, A enters into a contract to murder C. Then in that condition, this will not be a valid contract because the object itself is against the law. The last essential of lawful object is that when the court considered such type of contract immoral or against the public policy, then in that condition also it will not be a valid contract. With this, the essentials of the valid contract are completed. The next fold of my video is the types of contract. So there are various types of contract. In this video, we will be dealing with the valid contract, void contract, voidable contract and illegal contracts. So the first contract is valid contracts. So as stated in earlier also, the essentials of a valid contract. So any contract which fulfills all these certain essentials of contract will be termed as a valid contract under Indian Contract Act. The next fold is void contract. So any type of contract which defeats the provision of law and which does not fulfills the valid essentials of the contract, it will be a void contract. So there is a contract also void ab initio. So if the contract is with the minor, then at the first instance only it will be termed as the void. So it will be said as void ab initio. Void contract is basically a contract which ceases to be enforceable by law and becomes void when it ceases to be enforceable. For example, A contracts with B to have a supply of 100 bottles of liquor. But suddenly in the state of Bihar, the liquor is banned. So this contract will be termed as a void because it is not possible only to fulfill this contract, as the main object of this contract was the supply of liquor, and which is now going against the law. It is beating the provisions of the law. So this contract becomes void. One more example: if A enters into a contract with B that A will marry C, and if A will marry C, then B will give him 1 lakh rupees. So C dies. So with this, the contract will be void because now A will not be able to marry C, and the amount will not be given by the B in any condition. So the contract is void in the present situation. The next aspect of the types of contract is voidable contracts. Voidable contracts are those which are voidable, which are valid at the option of one of the parties. For example, A enters into a contract with B for the supply of any vase which A thinks is of 19th century. and is of famous princess. With this mindset, A enters into a contract with B, but later it is known to B that it is just a normal vase and does not belong to the old century. So now it is at the outset of B to conclude this contract as a valid or voidable. If B wishes, he can cancel this contract and this contract will be void. But if B wants to continue this contract, then it will be a valid contract. So it is valid at the option of B, at the outset of B. Then the voidable contracts, basically I'll just explain in 2-3 lines that what is basically the voidable contract. An agreement that leads to one or all the parties breaking a law or not conforming to the norms of the society is deemed to be an illegal contract. Illegal contract is the fourth type of contract. After valid contract, void contract and voidable contract, illegal contract is the fourth type of law, which says that the contract is illegal if it is done to beat the provisions of the law. Now, illegal contract. A contract opposed to public policy will also be termed as an illegal contract. For example, A agrees to sell narcotics to B. This is an example of illegal contract. The last type of contract is unforeseeable contract. Unforeseeable contracts are those that are rendered unenforceable by law due to some technical or unforeseeable consequences. The contract can't be enforced against any of the parties and it's a natural consequence. For example, A agrees to sell B 100 kgs of rice for 10,000. Now, but then there was a huge flood in the area and the rice crops were only destroyed. So now this contract is unforeseeable and cannot be enforced against either of the parties. Essentials of these type of contract is that there should be an unforeseeable consequence and both the parties, and means either of the parties, should be no condition or should be no authority to fulfill this contract. So the Contract Act has specifically declared few classes of contract as void, and they are mentioned from section 26 to section 30 of the Indian Contract Act 1870. So the first one is section 26, agreement in restraint of a marriage. So these are the agreements which are being entered into in the restraint of marriage. For example, A enters into a contract with B that B will never marry anyone. Now this agreement is void as A is restraining B from entering into a contract which is restraining him from a marriage. So these type of agreements are void. But the exceptions of this contract is the child marriage. So if the contract is with regards to a child marriage and the person is restrained from committing a child marriage, then this will not be a void contract because it's a valid exception. The next agreements which are void are mentioned in section 27, that is agreements restraining trade. For example, if person A is restrained from fulfilling any type of trade in specific area or a specific thing, then it will be a void contract, void agreement, because the agreement is restraining him to fulfill its fundamental rights, and the agreement is restraining him to trade on a specific object or to make his profession at a specific area. For example, every agreement by which a person is restrained from exercising a lawful profession, trade or business of any kind, to that extent the agreement will be void. So for example, A enters into a contract that A will never be allowed to do a business of rice. So these type of agreements are void at the very outset, because it is restricting him to do a trade or profession as per his wish. The next agreement is, which is mentioned, is under section 28 of the Indian Contract Act. These are the agreements in restraint of proceeding. So if a contract is restraining one party from going to the court, or from going to pursue any lawful or legal proceedings, then in that condition also the contract or the agreement will be void, because it is the fundamental right of anybody to approach the court. And if somebody is compelling him to enter into a contract to avoid going to court or to avoid pursuing his fundamental rights to complete the legal proceedings, then in that condition this contract will not be termed as a valid and these agreements will be void. But the exception here is the arbitration proceedings. If there is a contract, that first if there is any discrepancies or if there is any problem, then first the matter will be solved through arbitration proceedings, and if any of the parties is not happy with the decision of the arbitrator, then they can definitely go to any court. So this will not be a void contract, as it is not a complete restraint on his rights. The next agreements are the agreements void due to uncertainty. So if there is an agreement to do something uncertain, that is, A enters into an agreement with B that if A will give him 1 lakh rupees, he will bring moon from the solar system. So these type of contracts are not a valid contract, because this is a contract which is illusionary. It's a contract of uncertainty. This cannot be completed at any cost. So these type of contracts are also void in the eyes of law. The last type of law, the last type of contract that I will be dealing today is agreements which are vague. So the wagering agreements are void. The wagering agreements are void and no suit. The wagering agreements are void and no suit shall be brought to recover anything that has been won by a way of wager. Basically, a wagering contract or an agreement is one whose outcome is based on a future uncertain event, and one party will win and the one party is going to lose on a future uncertain event, and that event is not controlled by any of these parties. The best example of this is cricket betting. For example, A enters into a contract with B. A says that if India wins, he will sell his house to B. And B says that if Australia wins, then he will sell his house to A. So in this condition, it is an uncertain event that it will India win or an Australia win. And both these conditions cannot be changed by either A or B. So if India wins, then A is going to win, and if Australia wins, then B is going to win. So basically the wagering contract is a contract of uncertain event in which definitely one party is going to lose and one party is going to win. The exception of wagering contracts is horse racing. In India, the betting that is done by horse racing is not termed as a wagering contract and it is legal. Thank you.
Aradhya, thank you very much. It was like going to my law school days and hearing the lecture on contract. So thank you very much for that. This is why.